One of the most difficult things for my clients or prospective clients to understand is the following. How can someone, they tell me, file a lawsuit with things that are obviously false? I mean, it's so obviously false. How can the law permit that? But the thing is, in our business, in the litigation industry, we don't deal with false or truth. We don't really have that. We don't even speak like that. We have allegations, which is whatever someone alleges in a paper. We have findings of fact, which is whatever some judge or jury finds that's a fact in the case, an established fact. For example, the contract was signed in Miami. If the judge finds that the contract, based on the evidence presented, was signed in Miami, that will be a fact, a truthful fact of the case, and then we can move on to another fact. And then we have conclusions of law, which is basically the end of the case, where the judge or a jury decides, okay, based on the fact as established by the evidence and the law that applies to your case, we conclude that this is the truth. This is what happened. This is who wins. And I guess that's our version of truth or false, etc. So it's hard for my clients sometimes to understand that anything can go on a paper. We are constantly, for the majority of the life of a case, 90%, for the most part of the case, we're dealing with allegations that we have to deal with. Now, that doesn't mean that there are not procedural devices to fight frivolous lawsuits. I'll explain those in the next video.